Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Today, we are going back to the basics of criminal law, the elements of a crime. We're also going to spend some time diving into the two most important elements, causation and mens rea. No matter how far along you are in your legal career, I bet you know that criminal defendants in the United States enjoy a presumption of innocence. That is, they are innocent until proven guilty. That legal tenet has made its way into popular media and even into everyday speak. If you enjoy legal TV dramas, you may even know that to be found guilty, a jury must find that the defendant is guilty beyond a reasonable doubt. But your lawyer mind might ask, wait a second, what does that mean exactly? What must the prosecution prove beyond a reasonable doubt to get a guilty verdict? Great question. That's exactly what this podcast is going to cover today. It's a topic you should be sure to be really comfortable with as you dive into criminal law or procedure, as it is a building block to everything and an important reference point. So with that, let's jump in. Again, in order for a criminal defendant to be found guilty, the prosecutor must overcome the presumption of innocence and prove to the jury that the defendant is guilty beyond a reasonable doubt. To do that, the prosecution must prove that the defendant is guilty of each and every element of the crime or crimes charged beyond a reasonable doubt. Every crime has four necessary elements. 1, a physical act, the actus reus. 2, a requisite mental state, the mens rea, or intent. 3, causation, both actual and proximate cause. And 4, concurrence. The mental state and physical act occur at the same time. Everything is more manageable in small segments, so let's take each component part in turn. I am going to say this again because it is important. All four elements must be proven beyond a reasonable doubt. If even one of them is not proven, the prosecutor has not made its case and the defendant should not be found guilty. If the defendant is found guilty, that is certainly grounds for appeal. Okay, now that we have the broad overview, let's take a look at the first element, the physical act or the actus reus. The actus reus is what the defendant actually did. First, the actus reus must be voluntary. Second, an omission or a failure to act is generally not enough under criminal law unless 1, the defendant had a legal duty to act, 2, the defendant had knowledge of facts concerning the duty to act, and 3, it was reasonably possible for the defendant to act. When might a duty to act arise? Well, typically a defendant has a duty to act if they have a contractual duty, a parent-child relationship, a duty taken on voluntarily like police officers or official duties, a statute that creates a duty, or where the defendant themselves creates the danger. If the prosecutor can prove the actus reus, what's next? The answer is the requisite mental state, the mens rea. Under common law, there are 4 mental states that can be criminalized. We'll go over each of them, but note that each crime requires a different mental state. The requisite mental state is specified in the statute. To get maximum points, be sure you know which crime is being charged and which mental state is required as you analyze culpability. So what are the 4 mental states? We'll address the mental states in descending order of intentionality. The first is the highest standard, specific intent. That is, the defendant must have the intent or desire to engage in the conduct or cause a certain result. Put another way, if a criminal statute, say one that criminalizes first-degree murder, specifies that specific intent applies, that means a defendant cannot be found guilty of first-degree murder unless they intended or desired to cause their death or to take the action that resulted in that death, say shooting them. The second mental state is general intent. General intent requires the defendant to be aware they are acting in a certain way. The third is malice. Malice isn't exactly what you might think. It requires the defendant to have a reckless disregard of a known risk that harm may occur. Be careful of malice because it can trip you up. It sounds like it requires an evil intent. It sounds malicious, but it's actually one of the lower mental states. All it requires is a reckless disregard for a risk. Finally, we have strict liability. For strict liability crimes, no mental state is required at all. All that is required is the actus reus itself. One important thing to note here is that mistakes of fact are generally not defenses to strict liability crimes. Now that we've covered both actus reus and mens rea, the act and the intent, we'll turn to the third element, causation. The third element the prosecutor must prove beyond a reasonable doubt is both actual and proximate causation. If this sounds familiar from torts, good, it should. Actual causation is also called cause in fact or but-for causation. It exists when the injury would not exist but for the defendant's actions. Proximate causation looks to the natural and probable consequences of the defendant's actions and asks whether the injury was a foreseeable result of the actus reus. Now, in addition to looking to the defendant's actus reus and determining whether it was the actual and proximate cause of the injury, you also must determine whether there was a superseding intervening cause that interrupts the causation. That is, did the actions of a third party have a hand in the causation of the injury and therefore break the chain of causation? If there is, that cuts off liability. One important note here, a third party's action will only break the chain of causation if the intervening action was 1, independent of the defendant's wrongful conduct, and 2, not foreseeable. A good question to ask yourself when determining whether the third party's action was not foreseeable is, was it so out of the ordinary that it is not fair to hold the defendant criminally responsible for the injury? And finally, we have the fourth element, concurrence. Concurrence is pretty straightforward. It requires the prosecutor to prove that the mens rea and the actus reus occurred at the same time. That was a lot of law to memorize, and a lot of important law at that. If you need to rewind and review the material before we jump into some hypotheticals, go for it. If you're ready, we'll review 2 hypos adapted directly from the California bar exam. Reviewing hypos are a great way for you to test your knowledge and understanding of the law we've covered today, and a way to see what you need to review a bit more. So with that, let's dive in to a hypothetical taken from the July 2007 California bar exam. Dan stood on the steps of the state capitol and yelled to a half-dozen people entering the front doors, "Listen, citizens, prayer in school means government-endorsed religion, a state church. They can take your constitutional rights away just as fast as I can destroy this copy of the U.S. Constitution." With that, Dan took a cigarette lighter and ignited a parchment document that he held in his hand. The parchment burst into flames, and when the heat of the fire burned his hand, he involuntarily let it go. A wind blew the burning document into a construction site where it settled in an open drum of flammable material. The drum exploded, killing a nearby pedestrian. A state statute makes it a misdemeanor to burn or mutilate a copy of the U.S. Constitution. It turned out that the document that Dan had burned was actually a copy of the Declaration of Independence, not of the U.S. Constitution, as he believed. Dan was arrested and charged with the crimes of murder and attempting to burn a copy of the U.S. Constitution. 1. May Dan properly be found guilty of the crime of murder? 2. Dan argues he does not have the requisite mens rea for a conviction for the crime of attempting to burn a copy of the U.S. Constitution. Discuss whether this is a winning argument. You may have noticed some constitutional law issues in this question. If so, great issue spotting. We'll focus on the criminal law issues today. It's super important to be able to issue spot across areas and not to get tunnel vision on one issue. But for now, let's focus on criminal law and start with the first question posed. May Dan properly be found guilty of the crime of murder? To answer this question, we need to start with the elements of each crime. Remember, the 4 elements of a crime consist of 1. A guilty act, actus reus, 2. A guilty mind, mens rea, 3, causation, and 4, concurrence. Can the prosecutor prove Dan committed an actus reus, or a voluntary act? Here, Dan intended to burn the document, but it is not clear that he intended to drop it, let it drift into a construction zone, and explode. However, it's clear that Dan's act of igniting the document constituted a voluntary act. The fact that the heat of the fire had burned his hand and caused him to involuntarily let it go does not negate the fact that his act of burning the document in the first place was voluntary. Actus reus is likely satisfied. As to causation, Dan's intentional act of igniting the parchment document set into motion a chain of events. He let go of the burning document. It settled in an open drum of flammable material, and it caused the drum to explode and kill a nearby pedestrian. Actual causation is met. As for proximate cause, arguably, the pedestrian's death was an unforeseeable consequence of burning parchment. On the other hand, courts generally take a fairly broad view when it comes to foreseeability. The prosecution will argue the result was foreseeable because playing with fire is a dangerous activity that can foreseeably result in an explosion or injury. The increasingly common wildfires across North America are often started by innocent activities, but cause great devastation. Dan should be able to foresee such a consequence. For that reason, a court will likely find causation. Next is mens rea. Did Dan possess the requisite guilty mind? Let's start with murder. Remember, we look to the specific crime to determine the applicable mens rea: specific intent, general intent, malice, or strict liability. At common law, murder is the unlawful killing of a human being with malice aforethought, which is established by any one of the following states of mind. 1, intent to kill. 2, intent to do serious bodily harm. 3, reckless indifference to an unjustifiably high risk to human life, or depraved heart murder. And 4, intent to commit an underlying felony that resulted in death, also known as the felony murder rule. Each mens rea results in a different level of conviction for murder that will result in different penalties. On these facts, it is clear that Dan did not set the document on fire with an intent to kill. While an intent to kill may be inferred in cases where the defendant uses a deadly, dangerous weapon against a victim, a gun, knife, etc., that is not the case here. So Dan did not have specific intent. Neither did Dan act with specific intent to inflict great bodily injury on anyone. His act of burning the paper was done to make a political point to those that were present nearby. So a no-go on that one either. The state may try and argue that Dan's acts were done with an abandoned and malignant heart because by igniting the document around individuals, he acted in a way that demonstrated reckless and unjustifiable disregard for human life. I don't think the state will be able to meet their burden of proof under this theory, the malice murder theory, either. Here, Dan's act of burning the paper in this way was not the type of act that an individual could reasonably expect would lead to someone's death. If Dan had shot a gun in the air, for example, that might be a stronger case. Or if Dan was lighting a larger area on fire rather than just a document in his hand. This is certainly a factual analysis that a good lawyer should argue, but it doesn't rise to the level of malice murder on these facts. The state may try and argue that Dan should be convicted of murder based on the felony murder rule. Under this rule, a defendant is liable for all deaths that occur during the commission of a felony, whether he intended to cause the deaths or not. Instead, the intent to cause death is inferred from his intent to commit the underlying felony. Generally, the felony murder rule has been reserved for deaths that occur during highly dangerous felonies, such as rape, arson, kidnapping, robbery, and burglary. Felonies that are so dangerous that it would strain credulity to argue that the defendant had no idea someone could die from such actions. Here, the only underlying felony that is even close to Dan's actions is arson, but arson involves burning of a dwelling, which is not the case here. So Dan could not be convicted of the murder of the pedestrian based on the felony murder rule because he did not commit a highly dangerous felony. Because I don't think Dan had the requisite mens rea for murder, the elements of a concurrence is not met. The actus reus and the mens rea did not happen concurrently. If you argue, however, that he is guilty of malice murder, the concurrence prong is also met because his intent and his act happened at the same time. Depending on where you fall with malice murder, you'll reach a different conclusion as to Dan's guilt. Let's move on to the second question. Can Dan properly be found guilty of attempting to burn a copy of the U.S. Constitution, or should Dan win on his argument that he does not have the requisite mens rea to be convicted? Remember, Dan is being charged with attempting to burn a copy of the U.S. Constitution, even though what he actually burned was the Declaration of Independence. Regardless of the underlying crime, attempt is always a specific intent crime. Here, the state will be able to show that Dan had the requisite mens rea. From the facts, we know that he intended, that is, he had the specific intent to destroy a copy of the U.S. Constitution. So even though it was factually impossible for him to have committed that crime because he did not even have a copy of the Constitution in his hands, he had the requisite intent and can still be found guilty of attempting to burn a copy of the U.S. Constitution. Well, that was quite the hypo. I know it was complicated, but it was really a great example of how important it is to have a good foundation in the elements of criminal law in addition to knowing the law on the crimes being charged. For example, to answer the second question, you have to know that the state needs to prove mens rea, that specific intent is one of the levels of intent, and that attempt crimes are always specific intent crimes. With that foundation, the answer is pretty straightforward. Keep drilling yourself on the law and practicing hypos until you are comfortable enough with the material to spot all the different legal issues and puzzle them together in a well-written answer. It takes time and effort, but it is possible. In fact, we can get a little more practice in right now with one more hypo before we go. We'll make this one shorter so you leave today with confidence, knowing you can master this material. This hypo comes from the October 2020 California bar exam. Needing money and willing to do anything to get it, Don and Al set out for Vic's house around midnight to steal from him. On the way, Al said that he did not want to get involved, but Don slapped Al's face and responded, "If you don't come along now, I will break your legs tomorrow." At Vic's house, Don opened the unlocked front door and he and Al went inside. Don took a wallet on a table in the foyer and Al took an expensive ring from a bookshelf. Then Don and Al ran away. Don and Al were soon arrested and charged with larceny. Larceny is the taking and moving of another person's property without their consent with the intent to deprive them of it permanently. Can they be properly convicted? Well, what do you think? Do Dan and Al have the actus reus, mens rea, causation, and concurrence necessary to be convicted? I think the answer is pretty clearly yes. For the actus reus, Dan took and moved the property of another, the wallet, from Vic's home. Al did the same with Vic's ring. Because nothing in the hypo suggests they plan to return the property. In fact, it specifically states they needed and were trying to get money and that they both ran from the home. Both Al and Vic demonstrated a specific intent to deprive Vic of his property permanently. Al may argue that he was threatened to participate and therefore did not have the requisite mens rea, but Al also took affirmative actions after the threat to make it hard for him to argue that he was not acting of his own volition or intent. The actions Don and Al took were the direct and proximate causes of Vic losing his property, and the actus reus and mens rea happened concurrently. As such, absent any defenses, which are outside the scope of this podcast, Don and Al would both be guilty of larceny here. I hope that hypo was a helpful example of how to walk through each element of a crime and how to analyze the applicable mens rea. Before I leave you, I want to flag another episode that might be helpful to you. If today's episode was helpful and you want to go even further into mens rea, listen to our prior episode on the Model Penal Code's approach to mens rea or intent. I want to flag one important thing for those preparing to take an exam. Pay close attention to the question. The test writers may tell you which law to apply in answering a criminal law question, Model Penal Code, a statute given in the question, etc. If it does not, apply general principles of criminal law and procedure that we are discussing today. To be thorough, you can even note that you are applying general principles of criminal law and flag that others exist but don't apply in this particular case. For example, because this jurisdiction does not identify a specific statute or specify use of the Model Penal Code, general principles of criminal law apply. And with that, we're out of time. If you enjoyed this video, please take a second to give us a like and leave a comment. And be sure to subscribe to our channel so you don't miss any future content. If you have any questions, feel free to reach out to us via our website contact form at barexamtoolbox.com. Thanks for watching.